Good evening, everyone. This is Hangus Satanta Smoochworth, and welcome to my channel. The topic for today's video is the Supreme Court case, Masterpiece Cakeshop versus the Colorado Civil Rights Commission. Oral arguments for this case took place just a few days ago on December the 5th, and as a blockbuster case, we can expect its results sometimes toward the end of the current term, in July or August 2018. For those unaware, the case centers around a Colorado bakery that refused to make a wedding cake for a homosexual couple. In so doing, the bakery violated the Colorado human rights law. The Supreme Court must decide whether the bakery's actions are protected by the First Amendment. The ACLU is arguing on behalf of the respondents, namely a Colorado government bureau and the gay couple. The ACLU has an illustrious history. Every American, for the most part, has heard of the Scopes monkey trial or Brown versus Board of Education, and could probably name a few more ACLU victories as well. Outside of the classroom, the ACLU encourages education by having some college student employees stop passers-by for financial support. They patrol wealthy neighborhoods in liberal areas, like the entrance to Whole Foods, say. After some digging, it is still unclear to me what portion of the ACLU's over a $100 million annual budget comes from these college students' almsbeggars. One such man approached me on the street recently and asked me for a monthly contribution. I, like Emerson, grudge every dollar, dime, and cent, and so wanted to know where my money would be going. To gay rights, he said. Unsatisfied, I asked for a further clarification. And then he responded, to ACLU attorneys who, come next Supreme Court term, will put an end to religiously motivated discrimination against homosexuals. He was talking about the upcoming Supreme Court case that I mentioned before, Masterpiece Cakeshop versus the Colorado Civil Rights Commission, also known as the Gay Cake case. The case, as I mentioned, asks whether the free speech and free exercise clauses provide a legal defense to illegal discrimination. And an affirmative answer, I was told, could eventually lead to gays being denied apartments to rent. And also liberal urban areas, like the place I live, without apartments for gays, would, in a sort of fashion after the game of Mousetrap, eventually become devoid of diversity of all sorts. This slippery slope argument sounds a bit extreme, but in terms of judicial precedent, it isn't wholly without merit. Consider, for instance, Justice Scalia's Lawrence v. Texas dissent, in which he made a similar argument and has since been vindicated. In that case, the Supreme Court invalidated a Texas law that had criminalized sodomy. The court held that a state's majority's moral disapproval is not sufficient grounds for criminalizing sodomy. Scalia argued that the same line of thinking would invalidate laws against adultery, fornication, incest, and eventually homosexual marriage. Although the 14 years since that dissent have not resulted in the quote, end of all morals legislation. Whether you think morals legislation is a good thing or not, Scalia was in part right. The Lawrence case has been used as precedent to invalidate some legal prohibitions on fornication, on premarital cohabitation, and famously on homosexual marriage. Although mass home ownership or homelessness for homosexuals is far-fetched, there may be something greater at play than a baker's belief system. As the ACLU entitled one of its several blog posts about the case, quote, "It was never about the cake," end quote. After all, a different business owner let the couple have cake instead. This Masterpiece Cakeshop case is about the line between state power and individual rights. Over 100 years ago, in a case that predates the ACLU, the Supreme Court was forced to struggle with the proper intersection of individual rights, state power, and baked goods. This case, known as Lochner versus New York, led to one of the most controversial decisions in Supreme Court history. An underlying legal theory of that case, namely the freedom of contract, still sends shivers down the spines of law students and SCOTUS justices alike. What led up to that case was that the state of New York had passed a law that prohibited bakers from working more than 60 hours a week. The court held that a man has control of his labor, and the state can only interfere with that freedom in order to safeguard public health. Although most bakers then, as well as now presumably, would rather work less than 10 hours a day, that is more a matter of public preference and comfort than of public health. Thus the law was declared invalid. The Masterpiece Cakeshop case differs from Lochner in a variety of ways. Here the state is compelling labor, not prohibiting it. The conflict is not employer-employee, but rather customer and proprietor. Their freedom is of expression, not of contract. However, the similarities outweigh the differences. Lochner is a keyhole into early 20th century American life. One can see the German immigrant waking from his cot and walking the 2 or 3 feet to start the oven, which will occupy his entire day. But he is proud of his business, and even the Empire State will not stop him from succeeding. In the same way, Masterpiece Cakeshop lays bare a current America. A well-heeled couple decides their Cape Cod wedding would not be complete without a rustic reception in Colorado. A small business owner doesn't play along in their nuptial fantasies, so with the help of the most prestigious nonprofit law firm in the history of the nation, he is taken to task and to court. Like many famous ACLU cases before, this one will also provide quite an education. Thank you for listening. If you enjoyed this video, please like, share, and subscribe, and I will appreciate any thoughtful commentary below.